All right. Is my mic on? All right, so we have an amazing ending to today, and I'm delighted to introduce Commissioner Alvaro Bedoya. He is obviously a commissioner at the Federal Trade Commission. Previously was the founding director of the Center on Privacy and Technology at Georgetown University Law Center. He's been influential in research and policy at the intersection of privacy and civil rights. And I think the thing that I, admire and sort of am super impressed with Commissioner Bedoya is, his willingness to go meet real everyday citizens and ask them about their problems. And to me, that seems like a common sense approach if you're going to be a policymaker and law enforcer, that you would want to be representing the average American citizen. And as a person who grew up in DC and whose father was a member of Congress and a lobbyist, I think that that's important. Yeah. I think it's very important to ask normal people how things affect them as opposed to just listening to a lobbyist. I can assure you that a lobbyist is getting paid to say whatever they're paying, whatever they're saying. So, I'd love to just jump right into questions.
Let's do it. Great, yeah.
So, we've talked a lot about drug prices today. Prescription drug prices and access has been a big issue for you. This conference is about vertical power, and I was wondering, how do you think about vertical power issues in healthcare markets as contributing to high prices and access issues?
I think in a lot of different ways, and I realize I should have jumped in and said two things. First of all, thank you for having me here. Three things. Second, standard disclaimer, I'm speaking for myself, not the FTC in general, its staff or my fellow commissioners. And lastly, I want to recognize two very special people here, Catherine Sanchez, who is my lead advisor on healthcare, and my father-in-law, Dr. Abdullah Mirzada, who just retired after 45 years of serving New Orleans and Southeast Louisiana as a nephrologist. So it's actually really special. He'll tell me what I'm messing up. Those are the two dimensions that Catherine and I have been focused on. Obviously, there's nothing wrong with verticality per se. There very well could be a world where there's lots of vertically integrated entities and they are competing relentlessly with each other to pass on any savings they have from that verticality onto their consumers. But I think if you take a quick look at this industry, it's hard to say we live in that world. You've got three vertically integrated entities that handle 70 to 80% of the scripts overall nationwide. In many local markets, there's an even greater level of concentration. It is hard to say that the healthcare insurance marketplace is one marked by relentless competition on price. I think it's very, very hard to say that. And so right off the bat, that ostensible benefit of cost savings to the consumer, it doesn't seem on its face that we have the conditions that would push us toward those cost savings accruing to consumers. Secondly, the other hallmark, I think, of verticality is the aggressive use of rebates. And obviously, you could have rebates even in a non-vertically integrated world, but when you have vertically integrated insurers, PBMs down to pharmacy, the PBM serves as something of a gatekeeper to that population of insured. And so I think this is part of the marketing pitch of the PBMs. They use that and try to use that to get more rebates for the insurer. Now, my concern here on price has to do with the uninsured, because the rebates could cut all sorts of different ways, but one thing that seems pretty clear is that they seem to drive up the list price, the usual and customary price that someone who's uninsured, who falls in that donut hole, pays at the pharmacy counter. But I really appreciate what you said about talking to regular people. For me, the key issue is access. And so I promise not to give soliloquies to all your questions, but this is the one I really care about.
I like
all right,
stories.
all right. So I think it's important to take a step back and look at what pharmacy is. So we're at the National Press Club. I took a quick look. There is like, I think 9 pharmacies within a 7 or 8 block radius of here. You grew up in DC, you know, we've got 2 to 3 hospitals, quick drive from here, probably too many physicians to count within a 7 to 8 block radius. You go to working class, urban America, you go to rural America, and it's a very different picture. You may not have a pharmacy at all. And if you do, it's much more likely that they are an independent. And yet, you know, one of the key allegations you have from the independents is that these vertically integrated entities are systematically steering business to prescriptions to their pharmacies rather than these independent pharmacies. And I think 2 stories that have jumped out at me from these, well, one isn't from a visit, but I'll share one that was. One that jumped out at me that I've shared before was, you know, there's a child with cancer. The family shows up at a pharmacy in West Virginia, and the pharmacist says, hey, I have the cancer medicine right here behind the counter, but you know, the PBM is telling me you need to go home and get this via mail order, and it could take up to 2 weeks. Now, thankfully, the West Virginia Insurance Commissioner stepped in and got that family that medicine, but it took a couple hours, and that's not exactly what you want when a kid has cancer and needs medicine. I'll share with you one last story, though. So I was talking to some pharmacists from Louisiana, and they shared a story about what happened after Hurricane Ida in 2021, where there are 2 parishes south of New Orleans, and normally this area was served by a couple dozen pharmacies, and suddenly it was served by 5 or 6. There was a Walmart Supercenter, and there was 4 or 5 independents. And so people start showing up at the independents with prescriptions for insulin, and the independents are being told they're getting the do not fill screen, send them to the chain pharmacy down the street, which was either underwater, closed, or both. And so, you know, yes, there are worlds where vertical integration helps people, absolutely, but I think we need to look at the potential benefits of vertical integration and weigh them against the potential issues of price to uninsured, the potential issues about access to a very vulnerable part of the population, and see where that leads us.
And you know, the FTC's put out some policies. We're talking about high prices. We're talking about access. What tools does the FTC have in its investigative law enforcement rulemaking toolboxes to address these problems?
We have a lot. I think the one that's probably most front of mind to folks in the room is our 6B authority. We have the ability to subpoena large market actors and basically issue an industry report. We have one ongoing right now on the PBMs.
2 ongoing into the PBMs, right? You got the PBMs and the PBM, you know, the GPOs, right?
I think that's.
Yeah. Okay. Sorry.
We have that.
Yeah.
Number 1. Number 2, when you combine that with a compulsory process in a law enforcement investigation, that lets our staff get a 360 view of even as complex a market as the pharma supply chain. On the statutory enforcement side, obviously we have Sherman, Clayton, FTC Act, but within that, I'll tease out two specific tools that I think are very valuable. The first is, I hear there was some discussion of kickbacks here earlier, and we happen to have a law on that. A lot of people hear the words Robinson-Patman, which is technically a part of the Clayton Act, and they think price discrimination. And you should think of price discrimination. That's 2A, that's 2F. But tucked into Robinson-Patman is 2C, which is a much more straightforward, per se violation against certain kickbacks. And I think part of the issue that this law hasn't been applied, well, there's a lot of reasons we don't need to get into. It's been shrouded in this very obscure term of commercial bribery that doesn't actually occur in the legislative history. I think people don't really know what that term means. They hear the word kickback, they know exactly what it means. I'll just point out that, you know, while we had Commissioner Phillips, Commissioner Wilson there, we issued a 5-0 statement reaffirming the validity of this law. Now, obviously, my fellow commissioners then might have had a different approach to it, but that was a 5-0 vote saying 2C is still good law. And then the other point I'd flag is the FTC Act. This was a law that we can talk about more, but it was deliberately passed by Congress to get at not just the letter, but the spirit of competition law, and to stop violations of that law, to fix things before they break, to stop things in their incipiency, in their embryonic stage, and to let us become expert in an ever-evolving marketplace. And I think there's no denying that one of the newly evolved features in the last 20 years of the healthcare marketplace is these very substantial vertically integrated entities taking up, existing in the industry.
You mentioned kickbacks. FTC has authority. HHS has authority there. President Biden talks a lot about an all-of-government approach to competition. You know, I've actually heard from some people at HHS who they want to know kind of like what should we be doing more on competition,
Yeah.
which is kind of sad that they haven't thought about it. They needed an executive order, but at the same time, it seems like an opportunity to partner with the FTC. And I'm wondering how you see the FTC partnering with other federal agencies and state AGs to, you know, address these types of issues, the vertical power, the high prices, the access issues.
Sure. For me as a commissioner, I've been most involved with our peer state attorneys general and their staffs, who are just extraordinary. And I'll give you two examples that come immediately to mind. So I'm sure most of the folks in this room know about our settlement with Amgen and the Amgen Horizon proposed merger. We alleged that there was a pretty substantial risk that the combined entity might engage in some cross-market, cross-benefit bundling that would substantially hurt competition, and we settled it. We came to an agreement with the companies to prevent that. But one of the little noticed features of that settlement was that the 6 state attorneys general that filed it with us are able to monitor compliance with that settlement side by side with us. They have access to the same information we do, and so any world where there is not one law enforcement agency but 7 monitoring compliance with a very I don't want to say complex, but it's not a simple settlement, I think is a better world. So that jumps out at me immediately. Secondly, a lot of times state attorneys general, not surprisingly, know their states better than we do. And it's through those partnerships that we're able to actually hear directly from market participants that we may not otherwise be aware of. So recently, Catherine and I went down to Knoxville, Tennessee, and we met with Attorney General Skrmetti, the Lieutenant Governor in the state, and had a roundtable with independent pharmacy owners there about what they were facing in the market. And we had a similar roundtable in the outskirts of Philadelphia where we had staff from the Pennsylvania Attorney General's office. And so it's that kind of interaction you're talking about, getting out there. It really is in significant part to partnering with state attorneys general that we're able to do that.
And, I want to ask you about Section 5 authority.
Sure.
Because we saw in this recent lawsuit against U.S. Anesthesiology Partners and Wells, what's it called?
Welsh Carson.
Wells Carson. God, you think I would know it.
It's okay. Yeah. It's a lot of names.
They've written me enough hostile emails. We saw some Section 5 elements to that case. Same thing with Amazon as kind of complementary to these monopolization arguments. And, FTC can also refer criminal counts to DOJ. And I'm just wondering, how do you see states? I mean, they're really going to answer about FTC, so let me ask you about FTC.
Sure.
What types of conduct do you see as fitting under that Section 5 as really pertinent when it comes to healthcare, and how your work on that can help a state like California or other states with similar authorities think about, tackling, these problems with the whole toolbox at your disposal?
Sure. As we were walking in, we had a conversation about prejudgment, and so I'm going to answer this very broadly, but not talking about a specific case or state or specific matter. But I do think I can shed some more light on Section 5 that I think is necessary, because I think people hear unfair methods of competition, and if you just see the text of the law and don't understand the history of it, it's very easy to miss just how powerful it is and how powerful Congress intended it to be. So, so Section 5 is our core authority. We got it in 1914. Initially, it just prohibited unfair methods of competition. In 1938, It was expanded to include unfair and deceptive trade practices. But the remarkable thing about Section 5 is that Congress intended it to go beyond Sherman, beyond Clayton, which was passed roughly concurrent to Section 5, and both as a gap filler and also as a way to stop these practices before they go out and hurt people. And there's an aspect to the story of how we got that law that together with my colleague Max Miller, our colleague Max Miller, we wrote on when we issued the Section 5 policy statement. So Congress initially, at Woodrow Wilson's urging, proposed and passed out of the House of Representatives a law that specifically enumerated the acts and practices that were to be prohibited. And Louis Brandeis helped draft that. And then thanks to the intervention of a guy named George Rubley, who I believe went on to become a commissioner, they actually hit the brakes and they said, wait a second, we don't want to set this in stone. We don't want these provisions to just age away, and we're worried about literal innovation in anti-competitive practices. And there's some actually pretty funny passages in the legislative history where they say, well, they're going to innovate in breaking the law, basically, and so we got to capture that. And so they went back to the drawing board and passed a law and expressly said over and over, we want to stop things in their incipiency, in their embryonic stage. We don't want to wait till it breaks before you fix it. They actually don't say that phrase, but they use the other two. And in doing this, they gave the commission the ability to have an evolving expert authority to meet shifts in the industry that haven't been seen before. And certainly, as I said a moment ago, the rise in the last 20 years of there being lots of different health insurers, lots of, actually I forget how many PBMs there were more than 20 years ago, but they were not, for the most part, vertically integrated, and lots of different pharmacy providers, to a world where, depending on how you look at it, you have three dominant entities. That strikes me as a very significant evolution in the marketplace. And you asked what kind of conduct Section 5 might reach. For me, now it's a broad law, and so I would refer everyone to the policy statement, but for me the heart of it is when there is a powerful actor that isn't trying to beat competitors on the merits, but is just trying to take them off the playing field. For me, that is the heart of Section 5. And I think that what some of the critics of Section 5 forget is that over and over the Supreme Court ratified the breadth of this authority. Didn't always agree with how the FTC was applying it, but there's several times after this law was enacted, FTC used it, and the Supreme Court never clipped the breadth of those wings, and in fact repeatedly said, this was why we have FTC. It's supposed to be expert, it's supposed to be evolving, it's supposed to reach the spirit, not the letter. Yeah.
One of the things, and I'll just stay on this for a second, one of the things we heard about a lot today was how if you're an honest business, you're at a disadvantage. And is that kind of the type of situation where Section 5 applies, and you're an unfair method of competition is you're just sort of promoting, in some respects, a race to the bottom or something like that. And do you see a lot of that? I mean, to me, I see a lot of that, or I saw a lot of that in the conversation today. Does that make healthcare a particularly right place for this type of, for Section 5 to be applied?
So I don't know if it's a particularly right place or not, but I do think that Section 5 speaks to the use of market power outside of competing, trying to win on the terms of best service, best product, best quality, best availability. It speaks to the naked use of market power to take people off the playing field, and certainly not discussing at all the merits of some of the allegations that have been leveled against the vertically integrated entities. A lot of the allegations speak to that kind of conduct, right? It's the allegation of steering is an allegation where someone literally shows up at a particular pharmacy that they have chosen, right? This is the consumer. They know the pharmacy they want to go to, right? I think all of us have our own idiosyncratic preferences based on where we live and who we like, the pharmacist and the service we feel we get. But these consumers are showing up at particular places because they want to get served by them, right? And then they're being told, sorry, you got to go somewhere else, right? So I don't have any views on the merits of that allegation in Section 5, but it strikes me as that a number of these of these allegations point in that general direction. Yeah.
And we talked a lot about today also, how some, so I'd say conventional wisdom has sort of promoted vertical consolidation in many respects, vertical mergers. And I'm curious if you think it's been damaging to these markets that, for over 30 years really, vertical mergers have sort of been viewed by default as good, or at least okay, or pro-competitive, whatever language you want to use, take your pick. And was that wrong? And also, is that changing, both at the agency and just in the community around antitrust? Because we heard a lot of people say, look, the evidence is in, this has not worked, but I'm curious to get your view on sort of the history, how you think about this moment from a historical perspective.
Look, I want to focus on the forward-facing piece of that because I think there's a really positive story to tell. You hear a lot about stuff. You hear a lot of stuff about the current commission, but I want to point out that the commission voted out in a bipartisan way two critical vertical cases, Lockheed Aerojet and Illumina Grill. A lot of people forget that both of those were unanimous 4-0 votes. The former was a 2-2, both Democrats, both Republicans voting it out. The latter was 3 Democrats and Commissioner Wilson when she was in. And so I do think you're seeing a bipartisan shift towards greater skepticism of the benefits of verticality. And then the other thing I'm very excited about is the new draft merger guidelines. These are draft guidelines. They can change, but I think the combination of the rescission of the vertical guidelines and some of the language they had around those benefits that you're describing, combined with a set of guidelines that, yes, speaks to verticality, but looks at any proposed acquisition or transaction in a much more holistic manner, recognizes that there may be aspects of a transaction that are horizontal and vertical, and looks at these things as a whole rather than as this binary of vertical versus horizontal. I think that those things are altogether quite positive. Yeah.
And do we have time for a few more questions? So we're out of the standard questions. I have one. You brought up the merger guidelines. I'd love to ask. Innovation is in there as something that is important to look at. I'm curious to get your thoughts on, innovation as a analytical frame for viewing mergers and the merger guidelines and how that fits into healthcare, if you can talk about it.
Yeah, no, I agree. That's I like that aspect of the guidelines. Well, I have not focused on it terribly much. I've been much more focused on the labor aspects of it, which I can talk your ear off about. But look, I mean, I'll share one thing with you, which is that 2 years ago, I was a chief counsel for Senator Franken. I think we interacted briefly a long time ago in that context, and I worked with him on Comcast NBC and one or two other matters. But I'm a privacy lawyer, and so when I was nominated, there was a learning process where I had to literally order antitrust horn books and antitrust history books and kind of catch up on what I'd missed. And one of the things that you hear over and over is look, whatever you think of consumer welfare, it's not just price. It is service. It is quality. It is availability. It is all these other things. It is innovation. And one thing that jumps out at me, and I don't know if I'd call it innovation, but it's in that ballpark, is in meeting with a lot of these independents. And look, like I have had conversations with PBMs, I've met with doctors, with patients, but in the conversations with the pharmacists, you see 1,000,001 ways in which they're trying to do everything possible to help their patients. And whether it's providing delivery, I was in a room in Pennsylvania with folks from the PA attorney's office and a bunch of independent pharmacists, and I said, how many of you do delivery? And literally every single pharmacist's hand shot up, right? That's one thing. The other thing is in the mechanism of pill packaging. It's actually quite sophisticated. I'm sure there's some people that are familiar with this, but if you're not, There are lots of different and new ways in which these pharmacists who have these direct relationships with their patients can provide a service that is tailored to the particular needs of them. And they're not the only ones doing pill packs, but the combination of delivery, the combination of the way these prescription drugs are being delivered, I think is special and I think needs to be reckoned with. I think we can't just look at these things in terms of just price above all else. I think if we follow that bipartisan recognition that consumer welfare is much more than price, I think that it paints a very different picture as to what consumers get from vertically integrated entities versus the independents. And I think we need to pay attention to that.
You said you spend a lot of time thinking about labor, so I'm going to ask you a
Let's
question
do it.
about labor.
Yeah.
How do you view labor in healthcare? We had a lot of conversation today, and I think the most interesting aspect of the labor wasn't just there was monopsony, power issues by private equity, but there was also this idea that non-unionized physicians and a weak labor power among doctors leads to issues around corporate influence in medical decisions. That was a big topic today, was, instead of medical judgment being used to make a decision, you have these, corporate influences or, making the decision for the doctor.
Yeah.
And I'm curious if you've thought about that or just what you think about labor generally, when it comes to healthcare.
Yeah, I'll say three things on this. Let me see if I can remember all three things. Look, the first is, I think those state laws about medical providers needing to be in charge of health practices are tremendously important. And I think there's a lot of evidence out there that certainly the spirit of those laws is not being adhered to. There's a reason states pass those laws. It's because doctors take Hippocratic oaths. It's because doctors are experts. Doctors form relationships with their patients. I think it's a respected profession not just because people do well. It's because they're literally taking care of people and they care. And so I think that any state official with these laws in their books would do well to make sure they're being enforced both in terms of letter and spirit, number one. Number two, I'm sure everyone in here knows doctors. I'm sure there's some doctors in the room. I think the medical profession has changed dramatically in the last 10 or 20 years, where increasingly you have doctors saying, I feel like a cog in the machine. I feel like there's someone telling me where I need to go, when I need to do it, and giving me advice on my medical decisions from people who may not be qualified to do this. I don't control my hours. I don't see the upside if the business does well. And that, to me, jumps out as something that is just significant in and of itself in the quality of options in the labor market for physicians. Third, in the statement I did for the merger guidelines, for me, I go out and visit with people because I think it's the right thing to do. Also, to be completely honest, it helps me understand, what the heck is at stake. And for the same reason, I read a lot of testimony from people who come testify before Congress or before state legislatures. And for me, I didn't everything around labor crystallized when I read this testimony of a nurse, and she was a nurse up in Pittsburgh, and she said, "Hey, look, the COVID pandemic hit, and we weren't getting PPE, and so I went to my boss and I said, we need PPE, we need hazard pay, we need to be treated better. This is a dangerous situation." And I forget what exactly she said the boss said, but it was some version of, go pound sand. And so she started looking for new jobs. And she went online, and and I may be getting specific aspects of this off, but it's all in the statement. The right version's in the statement. But she goes, and first it's like 80 listings, and then when she eliminates, okay, well I've got kids at home. I can't work nights. And I actually don't have a car. I can't do these long commutes. I need public transportation. And it was a very large number, and it went down to, I think, 1 or 2 openings. And this is a nurse, right? This is a good job. And yet, when she looked at the labor market for her profession in her area, you know, it was either stay where she was or maybe have a shot at 1 or 2 other places. Maybe, right? That for me crystallized so many aspects of this, both how long it takes to look for work, the fact that, you know, people aren't toasters. Toasters don't care to whom they're sold, when they're sold, how often they toast. You know, we care about that. You care who you work for. You know, the person who is buying your labor needs to decide that they want to buy your labor. And so, but I think the last thing that jumped out at me is what she said. She said, you know, 20 years ago, there were something like 15 or 20 places I could have worked right in my neighborhood. And as a result of a wave of mergers, that's gone to, you know, 1 or 2. And so I think that, for me, encapsulated what's been happening in labor markets and healthcare in a way that I think a lot of people would assume is not the case if they're not familiar. They think you're a nurse, that's a great job. You're a doctor, that's a great job. I think, unfortunately, some moves to consolidation and concentration are reversing those trends. And I think Chair Khan and Commissioner Slaughter and I are really worried about that.
Yeah, you mentioned, you know, you have the FTC has a proposed ban on non-competes. I know that's been a big issue in healthcare labor markets, but we had someone say that emergency services in the DC area is so monopolized that the company doesn't even put non-competes on their doctors because they don't have anywhere to go. It was just a shocking thing. That was your reason not to have a non-compete. You know, I think there are better reasons not to have a non-compete, but just to get at your point there, you know, maybe you could talk about the importance of you know, the non-compete to you, or addressing non-compete issues in healthcare.
So I actually haven't looked too much at non-competes in healthcare specifically. And this is an active rulemaking, and so I should probably be a little more circumspect on it. But I think the evidence is very strong that they hurt competition in the labor market. And I'll leave it there. But yeah, there's a reason I was excited to vote for that. And you know, initially I wasn't really fully versed in it, but now that I've read the evidence, I'm glad to have voted out the proposed rule. Looking forward to reviewing all the comments and considering what to do next.
Do we have any questions in the audience? Here you go. Yeah, you can. If you stand up over here, you can use this mic if you don't mind.
Hi.
Question.
Sure.
You mentioned the Amgen Horizon settlement.
Yes.
And it's definitely good to see that and being able to extract terms from the big pharma companies. At least sort of from an observer perspective, it seems that the companies sort of agreed to similar sort of terms or behavioral remedies in the first place. So just maybe like doing a post-mortem on that. What is sort of the thought process between sort of agreeing to a consent decree with behavioral remedies versus maybe bringing a lawsuit and agreeing to a settlement to achieve sort of the same goal there? Perhaps there's just expanding scope of that remedy, but just curious if in general.
Yeah. So I can't speak to anything that did or didn't happen in the lead up to filing the matter, but I'm trying to think of other things I can say. Look, I think that a couple things for me jump out from that action. We're looking very closely at the pharma supply chain. We're seeing the same trends on price. I am particularly worried about biologics and biosimilars, and there are some astounding statistics on the percent of drug spend of biologics on overall prescription drug spend. I've heard as high as 50% of dollars spent on medicine in this country are spent on biologics. And I also, what I value about the settlement is that the commission is looking forward has seen a trend towards rebates and seen some allegations around the anti-competitive nature of those rebates, has expressed concern about them, and is working really hard to not wait until things break before we try to step in and move them in the right direction. So for those reasons, I was very happy with that settlement. And sorry I can't say more about what may or may not have happened before we brought the case, but I was very happy with what it landed, and I think that Chair Khan, Commissioner Slaughter, and I share a deep concern for the healthcare sector and the pharma supply chain in particular.
I've got one last question here.
Sure.
You really want to, make an impact with the average citizen, the everyday citizen, when it comes to pocketbook issues in healthcare. And is it, I'm going to kind of try to come up with a theme here. You have your Orange Book
Right.
statement. You have, possible enforcement there or action on that. You've got your insulin, discussion that you all have had, that the FTC has had. If I just,
sorry, that was me.
If I just look at these, I look at some of the Orange Book shenanigans seem to be around devices that are everyday devices, things that every person knows someone who has an inhaler, or knows someone who has to pay a lot for an inhaler monthly, or an EpiPen, or you look at insulin. Everyone knows someone who's on insulin, or and has to deal with the costs there. I'm trying to kind of come up with a theme here. It seems like you have a potential in the next, with all of these actions, to reach a lot of people who are affected by high costs, especially out-of-pocket costs. And I'm wondering if there's, any intentionality at the FTC to prioritize those types of issues where it's something within your purview. It affects a lot of federal dollars. It also affects a lot of out-of-pocket costs to people as a priority, from a priority standpoint.
Yeah, okay, so let me speak to one thing about what motivates me here. And let me be really frank, I think the state of lots of parts of American healthcare, not all of it, but lots of parts, particularly when it comes to working people, is shameful. You have people routinely going to GoFundMe to cover basic medical expenses, completely expected, normal things that would happen as you age, normal accidents. Yesterday I saw a GoFundMe for a guy who had a union job, good job. And even then, with the better benefits that a lot of unions are able to secure for their members, encountered some basic medical expenses, had to go to GoFundMe. For me, I think what the most stinging indictment's a little idiosyncratic, but I saw a couple years ago that if you go to the review pages for antibiotics, for fish antibiotics in some certain online marketplaces, it's full of people saying, yeah, I got sick, and my fish, in quotes, got fish, and it got sick, and they really needed help, and the vet was too expensive, and I used these, and my fish is doing better now. We are the wealthiest country in the world, and the idea that people are essentially routinely turning to charity and medicine for animals to help themselves is shameful. And so anything I can do to help them, if the law and facts are there, sometimes they are not, I will do. And I hope to start with urban America and rural America, because I think that most of the folks in this room, our premiums may go up, and that's a problem. But for a lot of folks in urban rural America, living paycheck to paycheck. We don't have a paycheck. It's a life and death issue. So that's where my heart is on this, and that's why I'm excited about every single thing you mentioned.
Thank you so much. Thank you so much for doing
Thank
this.
you.
All right. Thank you.
Thank you, my friend.
All right. Yeah. And thanks to everyone for coming to the conference. This has been a great day.